Mr. Leon Perera.
Mr. Speaker, sir, in recent years, Singapore has built up its reputation as a fintech hub. To preserve that, we have to ensure that our regulations strike the right balance between carefully managing risks and encouraging innovation. In 2018, Singapore was the second most popular country in the world for ICOs, and as of November 2020, 234 blockchain companies were operating in Singapore. E-money has also received high adoption rates here, and our consumers need to be protected. 77% of Singaporeans already use digital wallets, though there is still much room for improvement in the adoption of digital payments, as my parliamentary colleague, Mr. Louis Chua Keng Wee, will expand on. We have to ensure consumer confidence is not misplaced. Trust in people is earned, not given. Trust in business is also earned, and this is where a sound regulatory framework plays a crucial role. The Payment Services Amendment Bill is a step in the right direction of proactive regulation of the payment space. Sir, I shall focus the remainder of my speech on raising questions and suggestions in relation to the attributes of proportionality, enforceability and transparency in relation to the bill. I declare my interest as the CEO of a research consultancy that undertakes work in the fintech space, among other sectors. Firstly, sir, I shall speak on the expanded definition of DPT service provider in this bill. The expanded definition of DPT service provider will capture more activities, but more guidance is needed from MAS as to what constitutes certain activities such as control, inducing, and arranging. The expanded definition of DPT service provider will capture entities who offer token custody services, or entities who market or advertise token sales. Such entities will have to be licensed and regulated to the same extent as a token exchange. While it is laudable that the Payment Services Act, or PSA, is amended to greater meet the Financial Action Task Force, or FATF standards, it may be onerous for certain payment service providers to meet the same licensing requirement despite posting different or lower levels of risk. Here I would like to note in passing that my parliamentary colleague, Associate Professor James Lim, will be making a similar argument in the context of the money changer sector and small businesses. So the PSA licensing regime currently requires DPT service providers to meet relevant MAS requirements on cyber hygiene, periodic returns, business conduct, disclosure and communications, as well as annual audit requirements, amongst others. However, a token marketer or token custodian, such as a wallet service provider, for example, may not pose the same risks as a token originator or a token exchange to warrant such regulation by the MAS PSNO requirements. Specifically for a token marketer, Limb E of the proposed inclusion states that an entity who induces a person to buy or sell a DPT ought to be regulated, although this entity may not come into possession of the DPT at all. While some marketing may be performed by a DPT custodian, other entities, such as, for example, a professional public relations company asked to design or execute an ICO campaign, or even a blogger writing about hot ICOs, may conceivably be caught in the net. What then is the purpose of requiring such an entity to meet periodic returns and/or audit requirements if they are merely in the service of marketing a token? And might it be too onerous for such an entity to meet the whole suite of MAS PSNO requirements? Also, industry feedback suggests that the definition of arranging or inducing an individual to enter into a transaction is vague. Perhaps MOS could provide further clarifications on the exact types of activities that fall within the definition of arrange or induce. On token custodians, there are also concerns from stakeholders in the DPT space that the definition of control in the proposed limbs F to H is somewhat vague. While MAS had clarified that, I quote, a DPT service provider will have control of a DPT if it has the ability to control access to any DPT or to execute transactions involving the DPT, unquote, further regulatory guidance as to what this control exactly is would be helpful. I would also suggest that MAS consider, in the fullness of time, offering relaxations on MAS requirements for entities who pose less of a threat. For example, relaxing the audit requirements or periodic returns requirements for a token advertiser. Next, current companies who 1. Have a capital markets license and 2. Provide a token custody service must still hold a payment service license, with an exception available if a token's function is merely incidental to the business of that payment service provider. In the prior crypto wave in 2017, companies who dealt in digital tokens were required to hold a capital markets license if such tokens resembled securities or shares. Now these companies have to also hold a major payment institution license or standard payment institution license under the PSA if the tokens that they custodize hold a payment function. Perhaps more guidance on defining incidentality would be helpful for entities to make an assessment as to whether a token's payment function is merely incidental to its core business function of providing a custodial service. In addition, sir, it is unclear who the onus is on to determine whether a token is a DPT or not, whether that falls on the custody service provider to assess whether a token it seeks to custodize is a DPT, thus having a payment function warranting a license application, or whether it falls on the token originator to warrant that its token is not a DPT, and thus the custody service providers have no need to apply for a PSA license. For example, must a wallet service provider conduct its own analysis as to whether a token that it seeks to custodize falls under the definition of a DPT under the PSA, or whether it may carry out its custody service as long as the DPT provider is already a licensed entity? Perhaps there should be further consideration as to whether the PSA should provide an exemption for custody service providers in the event that the token issuer is already licensed. This is to prevent unnecessary dual licensing. Secondly, sir, I would like to speak on how the perception of increased regulatory powers by the MAS may spark fears of over-regulation and potentially excessively stifle innovation, especially among smaller players. The amendment bill before us provides additional powers to the MAS to, firstly, impose user protection measures on certain DPT service providers, and secondly, impose additional measures on any DPT service provider or class of DPT service providers by way of subsidiary legislation. While consumer protection is a foremost concern, an important concern, feedback from the industry, especially smaller firms, suggests that this is a cause for concern by them. For instance, the proposed amended S21A may be too onerous in the view of some in the industry. It should be borne in mind that excessive regulation could curb entrepreneurship in a sunrise industry and crowd out smaller players and startups, leaving only the bigger players to dominate. This in turn would be bad for entrepreneurship and innovation in the longer term. I would like to ask what steps will be taken by the MAS to ensure that smaller companies and new entrants to the industry are able to meet these enhanced regulatory standards. Thirdly, sir, the expanded definition of cross-border money transfer services raises questions in terms of its enforceability and benefits to Singapore in terms of congruence with other competing jurisdictions. This amendment bill expands the definition of cross-border money transfer service to require licensing of service providers like brokers in Singapore that actively facilitate cross-border money transfers between entities in different countries, although monies are not accepted or received in Singapore. Under the current PSA, such providers are not covered. While it is laudable that Singapore is taking the lead on cross-border regulation of VASPs and adopting FATF recommendations, there are two concerns. Firstly, this may be difficult to monitor and enforce if the flow of monies is from one foreign country to another foreign country. How does the government intend to monitor and enforce this? Secondly, while I acknowledge that this amendment is necessary to uphold the reputation of Singapore as a trusted financial hub, It is unclear if other countries are doing the same with regards to monitoring the movement of illicit funds or suspicious transactions with regard to DPTs from Singapore to a third country or vice versa. While according to an FATF review, and I quote, 20 jurisdictions advise that they have extended their regime to include value-added service providers or VASPs conducting operations from their jurisdiction, unquote, the review did not appear to identify the specific jurisdictions or provide specific details about these regimes. Furthermore, the review then noted that such a diversity in approach, and I quote, may present challenges in identifying which VASPs are regulated by each jurisdiction, unquote. In respect of other jurisdictions specifically, for instance, there do not appear to be similarly expansive definitions which have been implemented or proposed with regards to cross-border money transfers in Hong Kong or the Cayman Islands, even though these jurisdictions have proposed to enact or have enacted legislation in connection with the FATF guidelines. Hence, I would like to ask if the MAS will, going forward, monitor the extent of international regulation of VASPs in line with the FATF recommendations and calibrate the onerousness of our own regime in line with what is being done internationally, with an eye to our competitiveness. Fourthly, sir, I would like to speak about the need for greater transparency and less of a black box approach in the payment service license application process. The payment service license process requires firms covered under the PSA, the payment service license process required for firms covered under the PSA is perceived by some industry players as a complete black box. Many companies reportedly find themselves stuck on the waiting list for long periods. Moving beyond a completely black box approach to a greater degree of transparency could provide more support to viable businesses to get licensed and go to market faster. It may also enhance Singapore's attractiveness as a fintech hub. While MAS does provide some basic criteria, for example, base capital requirements, fit and proper requirements of shareholders and employees, no entity is familiar with the actual determining factors that make or break a license application. Companies may apply for exemption status to continue operating at a small scale for 6 months while waiting for the license, but cannot scale up during that time. These companies also struggle to account to their investors or shareholders and their future plans as a result, and as a result, go into hibernation or may leave the country. There are 366 firms who applied for exemption from holding a license under the PSA for specific payment services for a specified period while waiting for their license. And there are likely even more in the pipeline, namely, those who directly applied for the license without seeking exemptions, those who are still seeking legal advice and have not yet applied, and those who will only apply after this amendment passes. For example, DPT marketers and custodian service providers. There are 439 firms who currently hold the payment license. While it is understandable that the full licensing criteria cannot be disclosed due to the risk that some applicants may game the system, as it were, this has to be balanced against the need for some transparency so as to enhance Singapore's attractiveness as a fintech hub. With that in mind, I would like to ask the Minister for information regarding the proportion of successful applicants to total number of applicants and the average duration companies have had to wait for an outcome. I would also like to ask if the MAS would consider providing a clearer fixed timeline and process, including an appeal process, so applicants know when to expect an outcome. B, more resources to help innovative businesses understand and navigate the licensing process. For instance, Project Innovate by the UK's Financial Conduct Authority targeted support to innovative businesses in navigating the FCA's authorization process. This has achieved good results. Firms coming through this program in the UK are being authorized on average 40% faster than the standard applicant. I note that the MAS did launch the Payment Regulatory Evaluation Program in 2019, meant to assist payment service providers in seeking legal advice from registered Singapore law practices relating to the PSA. This entails a sample questionnaire for potential applicants to approach law firms with, and the list of legal practices legal practitioners, who can provide advice in relation to the PSA. But it does not provide targeted support like what is being done in the UK. Furthermore, this program will cease in January 2021, 1 year after the PSA has come into force and the transitional period has ended. And C, I would like to ask if the MES can provide high-level guidance on the criteria determining approval or rejection of a license. Thank you.
Order. I propose to take a break now. I suspend the sitting and we'll take the chair at 5:35 p.m. Order, order.